Hello friends, in the series on the income tax cases, today we will discuss a very important case from the perspective of the assessments of the entry operators. It has been seen that the entry operators are highly active in India and they provide accommodation entries to the various persons and charge commission on that. It has been seen that the revenue make searches on them, take the data from them and try to reopen the cases of the beneficiaries under section 148, and when the assessment of the entry operators are done, they are charged at some commission rate and then a very nominal income is added into the income of the entry operators. Sometimes it happens that the entry operator provide the details of the credits in their books and sometimes they are not able to provide the details of the credit. The question before the Honorable Bombay High Court in the present case was that in case when the entry operator is not able to explain the credit in its books, whether in that case also the commission income is to be charged on the income of the entry operator or the addition under section 68 can be done. This issue has been taken up by Honorable Bombay High Court in a very recent judgment and very important judgment. The name of the case is Principal Commissioner of Income Tax versus Buniyad Chemicals Ltd. This case is reported in 474 ITR at page number 452 and the date of the judgment is 17th March 2025. In the present case, there was a search on the entry operator. He admitted in that search and gave a very bold statement that I am an entry operator. And in that statement, he categorically mentioned that he is maintaining his books and even the books were audited. But he was not able to provide the details of the credits which were there into his bank statement. The assessing officer made the addition under section 68. When this matter came before the CIT appeal, the CIT appeal gave a very recent order that the commission income at the rate of 0.37% should be charged on the credits for which the assessee has given the details, and section 68 will be attracted for the credits for which the assessee is not able to give the details. When this matter came before the tribunal reduced the rate of commission from 0.37% to 0.15% and eliminated the difference between the unexplained credit and the explained credit, meaning thereby that the assessee was left scot-free only by charging the commission income of 0.5% on the transactions which were there into the bank statement of the assessee. The revenue challenged this order before the Bombay High Court. The contention of the assessee was that he was not maintaining books of accounts, and section 68 is attracted only when there are books of accounts. For this, the court said that since the assessee in his statement has categorically mentioned that he is maintaining books of accounts, so the contention of the assessee that section 68 is not applicable for him is not correct. Further, the court said that if the assessee contention is to be adopted that there is no books of accounts, but if the assessee was required to maintain the books of accounts and he is not maintaining the books of accounts, then the assessee cannot be given the benefit for his wrongdoing. So in the present case, the bold statement of the assessee that he is an entry operator and he is not maintaining books of accounts is self-defeating and destructive. The court said that in the present case, the entry operator, that is the assessee in the present case, cannot be scot-free by just giving a statement that an entry operator, and he cannot absolve himself without giving the details of the credit in the bank statement. The assessee contention that the bank statements are not my books of accounts is not accepted because the assessee is maintaining the books of accounts. Even if the assessee is not maintaining the books of accounts, but he is required to maintain the books of accounts, the section 68 will be applicable. The court said that even if there is no section 68, even then, if it is found that there are some credits into the books of accounts of the assessee and the assessee is not able to prove the identity, genuineness and creditworthiness of those transactions, even then that amount should be taxed. The court was of the opinion that the statutory taxes cannot be evaded by such a bold admission by the assessee, and in the present case the tribunal should not be tempted by the concession of the counsel because the tribunal was the last fact finding authority. So in the present case, the court said that the order passed by the tribunal is perverse, and the Bombay High Court upheld the order of the CIT appeal and also ordered the various agencies like the ICI, SFIO, CBI, ED to take the appropriate action as per the law against the assessee and the professional who was auditing the books of accounts of the assessee. Friends, this case is very important because bold statements by the entry operators that they are entry operators, now they are very hard hit by this judgment of the Bombay High Court. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Buniyad Chemicals Ltd, and this case is reported in 474 ITR at page number 452, and the date of the judgment is 17th March 2025. Thank you, friends.